The next amendment is the gentleman from Florida.
Thank you, Mr. Chairman. I'd like to call up the amendment, number 1.
Amendment to H.R. 3817 offered by Mr. Klein. At the end of Title V, insert the following. Section 513.
Ask unanimous consent the amendment be considered as read. Order. The gentleman from Florida is recognized for 5 minutes.
Thank you very much, Mr. Chairman. Mr. Chairman, there have been a lot of issues raised regarding the treatment of investors in the Madoff Ponzi scheme. And I know other members of this committee share an interest in this topic, and there are issues relating to SIPC involvement. There are issues relating to trustee involvement and treatment. There are issues relating to tax treatment of these losses. But one of the things that I've heard most from a lot of constituents that I have in Florida is great concern about inconsistent interpretation of the law when it comes to the clawback or the gathering of the assets back in. In particular, the issue relates to the fact that people had received statements over the years that said a particular thing, led them to believe without any reason otherwise that they had a certain value of their investments. They put money in. Some people took money out over the years to pay taxes. Obviously, had to pay taxes as their accounts were allegedly increasing. And now, after all this fact has occurred, the trustee is taking a position that apparently there are different legal interpretations, but it appears, at least in my reading of it, to be inconsistent with the law and the way these have been treated in the past. Mr. Madoff's Ponzi scheme is thought to be the largest securities fraud in modern history. He defrauded thousands of people, obviously many in my congressional district, both individually, and it's had a great impact on our community as well, and other places around the country through charitable contributions. There has been a very dramatic impact by this failure. The episode was an embarrassment at the SEC. We know the stories now about information that was presented a long time ago and was ignored. Time and time again, the SEC received information, didn't do anything with it. And certainly, if there's anything we've learned about this scandal and this year of a global economic crisis, is that we need smarter oversight. This doesn't mean the government has to check up on every move of every investor, but this means that someone like Madoff can't get away with this type of incredible scheme. The committee is currently working on a number of bills that will significantly strengthen the financial regulatory system, and I'm confident that these measures will achieve a smarter, comprehensive reform. But it is essential for the American investors to know that when they put money in investment accounts, and there's an SIP symbol attached to those accounts and those investment companies, that there is trust and there's confidence that their investments will be protected. And we're not talking about bad investments. We're not talking about all those kinds of things. We're talking about the solvency and when failures take place. It's also important, as I said, to follow the law. We know that there are some investors that participated and were complicit in this fraud, and they, along with Mr. Madoff and anybody else who was involved, need to be punished. There need to be consequences, and the book needs to be thrown at them, and they need to spend the rest of their life in jail, from my perspective. But there are a lot of people, most people, who either participated either directly through funds that they put directly into Madoff accounts or through feeder funds where they participated through investing in accounts that were even as large as $1 billion, and now they're finding out that there's nothing there behind them. So the purpose of the amendment today is to get the trustee to, number one, take what I believe to be a consistent legal position from previous situations where there have been failures, recognizing that there are always winners and losers, but all we can ask for is fairness and consistency. And on a going forward basis, Mr. Chairman, I know that this committee has now indicated an interest in looking at the whole investor protection system, including the SIPC, whether it's properly funded, whether it has exclusions which will undermine the confidence of the American investor. As we rebuild the economy, we need to make sure that people know when they put their money in that that money will be secure and there's a fund to back it up. And that means there needs to be enough money in this fund and that the participants who fund it put enough money in there so if you have a major failure, that there will be enough money to account for that. And secondly, that there's a fairness doctrine that goes along with it. So, Mr. Chairman, the purpose of the amendment, as I said, is to offer a way that Congress believes is appropriate for consistency in the interpretation of the Madoff investors. I know that Mr. Kanjorski has indicated that he has offered to bring together experts, and various people have been involved in this, and that we can consider some some action that's well thought out and well designed that will protect the people in the past and avoid this kind of major catastrophe from having occur in the future. I guess I would just say that based on the conversation with Mr. Kanjorski and the chairman, I'll withdraw the amendment today. It is a very important issue, and I don't want to...
The gentleman with I want to thank him, the gentleman from New York and others. Yes, the Madoff thing has clearly revealed serious gaps in investor protection, and it is our responsibility, and we'll be working together to fill them early next year.